Judge, is there any way that I can turn this so she can be seen, or?
You're welcome to turn it. Yep. Just don't break it.
Right. Are you able to see her? Ms. Patel? Are you able to see your client?
I can see her. Not, I mean, she's very small, but I can definitely see her.
That's as big as she's gonna get. She's
Right.
closest to the Clear Touch machine. So we have a Ms. Harris on the call. Who is Ms. Harris? What's her connection to our proceedings?
Your Honor, that's Celeste Harris. That is Mr. Grimes's mother. Looks like that is Mrs. Harris.
Excellent. So let's get back to Ms. Hines. Good morning, Ms. Hines.
Good morning.
You are here. Oh, we were in the midst of having a discussion of what we were going to try to do with your case. Ms. Hall, are you in a position to go forward with a bond hearing, or is this something we need to reset so that you can provide notice to the alleged victim or victims in the case?
Your Honor, honestly, the state would need a reset to get in contact with our victim. As I was researching the case, I realized that it wasn't a probation revocation, but then in trying to contact the victim, it looks like she's in the wind. My investigator has been trying to locate her since Thursday. We can go forward. I just will be going forward without actually making contact with my victim. We did make contact with her grandmother, who haven't spoken with her in years. So that wasn't a good contact, but that's where we are right now, Your Honor.
And Your Honor, I did email Ms. Hall September 24th to let her know that I would be addressing bond today. It's possible she might not have seen that email, but I will forward it again to you, Ms. Hall.
Okay,
Yeah.
well, and I appreciate Ms. Hall saying, look, we can have the conversation. If after I hear everything, I think it's important to delay a few days in making my decision to give the state a little more time to try to contact the alleged victim, I'll let folks know. It may be that that's something that doesn't weigh real heavily in how we sort it out, because I can always have as a condition no contact with the alleged victim. Let me get the case up on the screen. Okay, we're going to go on the record now. Ms. Hines, I'm Judge McBurney. I don't think we've met before. You are here because you were indicted last year for aggravated battery and aggravated assault. Today, we were going to do what's called your arraignment, but you and Ms. Patel may have discussed this. She's going to file some paperwork that will take care of the arraignment piece. So we're going to skip that, but we are going to talk about bond. Ms. Patel is going to tell me why you ought to be allowed to stay out on bond until your case is resolved. And Ms. Hall, the prosecutor, who's also on the screen there, you can see your lawyer is the one in the middle, and Ms. Hall is actually the one waving. She's the prosecutor. She's going to share with me the state's perspective. She may agree that you should have a bond, but it should be different than what your lawyer is asking for. She may oppose bond, and I'll hear from her, and then I'll let you know what I'm probably going to do. And it may be, as you've heard us discussing off the record with you here in the courtroom, that I give the state a little more time to try to track down the person who is the alleged victim in your case. I don't know anything about your case. I'm going to learn a little bit about it and more about you while I hear from the lawyers, okay? Now, Ms. Hines, this is a little different than the normal setup. Normally, back a year ago, you'd be sitting next to your lawyer here in court. Normally, a month ago, you'd actually be at jail on the screen, and Ms. Patel would be here. But today, we have yet another permutation, and you're here in court, and your lawyer is not. You have a right to be in court, which you are. you also have a right to have Ms. Patel sitting by your side rather than on a screen in a different location. Do you waive your right to have Ms. Patel by your side so that we can go forward with the hearing? Or would you like to reconvene in a few days where you can have Ms. Patel by your side?
I waive.
You waive. Okay, then we'll go forward with the bond hearing. And I'll ask Ms. Patel to get us started.
Thank you, Your Honor. Ms. Hines is actually here on a pretrial services bench warrant. She went through, she was directly indicted. She had a plea and arraignment where she received a $40,000 bond, $20,000 on each count. Pretrial issued a warrant after they stated after some time she had stopped reporting. In speaking with my client, she indicated that she had started reporting and that she had missed a date and had called pretrial services to reschedule the date for her to report, and she never heard back. She called again, did not hear back, and then she, at that point, was afraid of reporting because she was afraid that there might be a warrant out for her. I explained to her that pretrial services is fairly patient with individuals when it comes to rescheduling their reporting dates, and that there was likely not a warrant out for her at that time, and that should she be placed on a pretrial signature bond again, that she needs to report even if she's missed her regular scheduled reporting date, because pretrial services knows these individual situations and that they're fairly patient. That being said, Your Honor, my client does have 6 kids. 2 of them are staying with one sister. The other 4 are staying with her brother. I've spoken with her sister. They definitely need their mother home. Her 8-year-old child is he's doing remote learning, and it's been quite a hardship on her family members to help with having him go through school. Before she was arrested, Your Honor, she was doing hairdressing work. She was working before that at the Georgia State cafeteria, and then COVID hit. And so she lost her job at that time, but she is able to maintain employment. If she is released, she would be able to reside with her sister. I do not believe, when I check the system, that there are any felony convictions for her. The complaining witness in this case, they know each other. My understanding is that this did happen some time ago, and since then they have reconciled, and that they are on good terms. This incident surrounded a man, and neither of them have this person in their life anymore. And so, Your Honor, we would ask that the previous bond for Ms. Hines be reinstated, and that she be allowed to be released on pretrial services.
Okay, so the alleged victim is Ms. Alexander, and the allegation is that Ms. Hines cut her with a bottle in September of last year. So it's not so long ago. Case is only about a year old, be a year and a month later this week. And I get it. Thank you for orienting us, Ms. Patel. It's not that Ms. Hines missed court or this is her first appearance. She had appeared, she got a bond. I see it on the screen, $40,000 bond. But she missed a pretrial services event and then decided not to resurface until we found her. And now she is unhappy with that decision and wants to get back out and be with her kids. Ms. Hall, tell me the state's perspective on Ms. Hines's eligibility for a bond or return to bond and pretrial supervision.
Your Honor, learning or getting a better understanding of why she was picked up on the pretrial warrant. And because she was already out on a bond, we haven't had any issues with her and the victim, or at least the victim has not contacted us and said there was any issues. The state doesn't have an issue with you reinstating the pretrial bond, and she go back on bond while we work out the case, or while we discuss the case, Your Honor.
Okay. Ms. Patel, where would Ms. Hines stay? I have an address that's an apartment on James P. Brawley. Is that where Ms. Hines would return, or is it a different address?
It should be the same address. If I have 412 James P. Brawley, apartment 1, and that is where her older sister resides.
Okay, I've got apartment 4 in the system, not apartment 1. So I guess we'll hear from Ms. Hines. We need a good address so that she gets notice as to when she needs to come back to court to work through her charges. I'm just seeing if I can get my hands on the warrant. Nope, I can't find it. All right. Ms. Crawford, do you have any information about Ms. Hines and a criminal history? And good morning to you.
Good morning, Judge. Ms. Hines only has one inactive case from 2011. It's a cruelty to children and aggravated assault case, but it's not active.
Okay, was that a Fulton case?
Yes, sir. Fulton County case.
All right, thank you.
You're welcome.
Ms. Hines, where would you be living if you were put back on bond?
James P. Brawley, apartment 1, 412 James P. Brawley.
Apartment 1?
Yes, sir.
Okay. So, Ms. Patel, I guess if you could also do a change of address, it's a very minor change of address, but it's still a change of address because the system has Ms. Hines at apartment 4. Were you ever in apartment 4?
No, sir. I
Okay.
was apartment 1.
Okay. So Ms. Patel, if you would do the waiver of indictment, and that would get you in the case, because I don't think you are listed as, there's no lawyer listed for Ms. Hines. The waiver of indictment, your entry of appearance, and then a change of address where you enter the address you shared with me, and that'll get the apartment number changed. Ms. Hines, Ms. Patel says that you and Ms. Alexander have patched things up. Is she someone who lives in your neighborhood, or you work together? Why would you all have any contact now?
We grew up in the same neighborhood, and we was working at Georgia State together.
Okay, but you were on bond for a while. When you weren't supposed to have any contact with Ms. Alexander. So
no, I didn't.
you didn't.
We
Okay.
was working at the same place, but at the same time, she did come forward to me and apologize. So.
Okay. All right. Well, I'm going to put the same bond in place, so you'll need to not continue to have no contact with her. So don't reach out to her, don't text her, don't have friends reach out to her to say you need to do X or Y or Z. Now, Ms. Patel may try to contact her, and that's fine. Your lawyer can do that. But if Ms. Alexander shares with the prosecution that you're bugging her in some way and you need to make these charges go away, that's going to be a reason to say you really should not be out on bond with your kids until we work this out.
Yes, sir.
Allegations are serious. They may get resolved in a different way, but until then, you need to make sure you're going your way and Ms. Alexander is going her way. Now, you can't stop her from reaching out to you, but if she does, you need to tell her, I can't talk to you right now. Talk to my lawyer. And it may be that Ms. Alexander has helpful things to tell your lawyer, but she needs to be talking to your lawyer and not to you.
Yes, sir.
Ms. Hall, the bond had the standard conditions, show up for court, no contact with the victim or the victim's family, et cetera. Anything else you'd want to see as a condition, or you're comfortable with that?
Comfortable with that, Your Honor.
Okay. Then what I'll work with pretrial services to get the warrant out of the way. You need to stay in touch with pretrial services. It's not their job to find you. You need to find them. And if you have to, you got 6 kids, something may come up and you can't make a meeting, then right after you're able to get your hands on a phone, you call pretrial saying, hey, I'm sorry, my kid was sick, X or Y, and they'll work with you. If you keep missing meetings, they'll think something's up, and then they may say, we cannot supervise Ms. Hines. And your lawyer and the prosecutor and I can talk about that, but it's real important that you stay in contact with pretrial supervision, okay?
Yes, sir.
All right. Ms. Nelson, anything else we need to do on the record in connection with Ms. Hines, or are we all set?
No, I think you're all set when you said $40,000 with pretrial supervision level 3.
Yep.
Thank you.
Okay. So Ms. Patel, we'll look for those filings, the change of address, waiver of arraignment, entry of appearance, and then we'll just make sure this case moves along.
All right, thank you, Judge.
Great. So Ms. Hines, you should be out in the next day or two. If you are not, reach out to Ms. Patel and she can figure out what got stuck. But by the end of the week, you should be back at apartment 1.
Thank you.
All right.
And you're
So
back, or go ahead.
we're going to take a couple-minute break. The deputies need to get Ms. Hines down the distant working elevator. They'll get Mr. Grimes up. So the next thing we're going to do is Mr. Grimes. And then we've got at, I think, 10:30 or 10, soon after Mr. Grimes, we'll take care of Mr. Goolsby's situation. Pardon me? Oh, we already have Mr. Mr. Grimes? Great. Well, just like that, don't go anywhere. Mr. Grimes is coming out. Are you done, Ms. Patel?
Yes, Your Honor.
Okay, remember Tuesdays, inmates are coming over. If you've got someone on, double check with Ms. Nelson. If you see a client that you don't need brought over, we don't need to use that space. But that's what the Tuesday calendars are typically going to be.
Okay, thank you, Judge.
You're welcome.
And may I be excused?
Yep.
You did?
Uh-huh.
Are you Mr. Grimes?
Yes, sir.
Good morning, Mr. Grimes. I'm Judge McBurney.
Good morning.
We are here to talk about a probation revocation issue that you've got. We have your lawyer, Mr. Collins, who is, says Sean C. on the screen.
I'm not sure why it doesn't show my full name, Your Honor. It's Sean Collins.
I understand. So that's Mr. Collins. He's your lawyer. And then Mr. Williams, are you handling this for the state?
I am Judge McBurney. Yes, I am.
Well, how come you're parachuting in and elbowing Ms. Hall out of the way?
Well, Ms. Hall wrote me back in. This was my case as a conflict. It was a conflict case originally. And so she let me know there was a VOP to handle.
Okay,
and Miss Nelson sent that to me. I also have Miss Deborah Singleton here. She was, it was an SB 440 case originally, and she's been helpful to the state in trying to resolve that case and the other co-defendants, and then also helping me to kind of get up to speed on the revocation.
got it. Okay. So Mr. Williams is the prosecutor, Mr. Grimes. And what we need to work through up front is what's happening with the allegations. So you are, it's alleged in the petition to revoke your probation that there were two things that happened that should not have happened. The first is it's alleged you broke the law while you were on probation, specifically that you committed a theft by receiving stolen property in May of last year in College Park. I don't know anything about those charges, but presumably you got arrested. Theft by stolen property is often you're driving a car you shouldn't be driving, but you don't need to give me any specifics on that. The second alleged violation is that you did not get your GED or make any progress towards that. That was one of the special conditions of your probation. You had a long term of probation, and during it, you were supposed to get your GED. So I'm going to ask Mr. Collins to get us started by letting me know if you are admitting to any of these allegations or if you are contesting them. Because if you're contesting them, then the state has to prove them. Just because it's on a piece of paper doesn't mean it happened. So Mr. Collins, you may have already engaged with the prosecutor on this. Is Mr. Grimes admitting to any of these allegations, or are these things that the state's going to need to prove up?
Well, Your Honor, I want to be very clear about the scope of my representation. So Fulton County assigned Mrs. J to be the public defender in the case. I reached out to her on multiple occasions, was unable to make any kind of contacts. His mother hired me for the sole purpose of trying to have this hearing because he has been incarcerated for what I believe to be over 5 months. So she was having trouble getting this on the actual calendar. So without knowing too much about the specifics, I would certainly think that Mr. Grimes is denying this allegation.
Okay. Can you give me the last name, maybe spell the last name of the lawyer you thought the public defender was assigned to this?
Yes, J-A-D-E, Jade.
Okay, I'm not familiar with that public defender, and that's not someone assigned to my division. That may be part of the delay here, and we can work through. It looked like Mr. Grimes had Kenneth Shepard when he entered the plea in his case. Mr. Williams, were you the ADA handler? It sounds like you were the ADA who took the plea.
Yes, Your Honor, I did.
And was Mr. Shepard Mr. Grimes's attorney then?
He was.
Okay.
Mr. Shepard was, and then Dennis Francis, he had a resentencing when he turned 17, and Dennis Francis represented him then. So there is a conflict, I believe, with the public defender's office.
Okay. Well, I noticed that there are two co-defendants, DeJuan Johnson and Deonta Johnson. So the PD's office may have represented one of the Johnsons. But we can work through that. Today, it's Mr. Collins who is representing Mr. Grimes. And Mr. Collins is letting me know that Mr. Grimes is contesting the two allegations that he violated the law in May of last year, and that he has not taken any steps towards his GED. Do you need time, Mr. Williams, to get witnesses together to prove up the theft by receiving stolen property? Is that a CP case? Do you know? It's an unindicted allegation if it's in Fulton?
Yes, Your Honor. even though there's just one listed in the petition, I think there might be some other charges separate to that, but I would need and request a continuance to prepare for that, and also to see if in the interim we couldn't get a resolution together for your honor.
Do you
Without it.
have the CP number for the death by receiving?
Yes, I have two numbers. Ms. Singleton helped me with that today. 19 CP 183752. And then there's another number, 20 CP 190790.
Okay, now I'm seeing the name Jade would be the first name of Ms. Valmond, VALMOND, who is handling, for now at least, Mr. Grimes's 20 CP case, which is an entering auto allegation. So Ms. Valmond may be a public defender who works in the pre-indictment side of things. If we look up the older CP case, Mr. Grimes has a TJ McCubbin, also pre-indictment, and that's entering auto. That appears to be the one that matches in time with what's alleged in the petition. So Mr. Williams, it is not alleged in this petition that Mr. Grimes has the 20 CP case. So that's not something that I could consider unless and until there's an amended petition or an addendum to the petition, because Mr. Grimes and his lawyer, Mr. Collins, would not be on notice that that's a basis to revoke. I'm not putting my head in the sand. If I were also, it was brought to my attention that subsequent to the May 2019 entering auto arrest, Mr. Grimes had yet another arrest. That's something to consider, but it's not a basis for a revocation unless and until someone from Department of Community Supervision updates the petition. That doesn't mean Mr. Grimes shouldn't want to try to resolve everything. I know that we are very much encouraging the DA's office and defense attorneys to, if it makes sense, to allow cases to be accused and deal with the accusations so that these open, unindicted, but accusable cases can be resolved. And Mr. Grimes has now accumulated 2 of them. It's just that the more recent one is not part of the petition to revoke. So it does sound like Mr. Grimes' attorney and Mr. Williams having the conversation is probably a good one, because I don't know that resolving this petition would necessarily resolve all of Mr. Grimes's business here in Fulton County. Let me see what. People keep giving Mr. Grimes a bond, but he's going to stay put until we work through these different issues. So how much time, Mr. Williams, would you want to figure out which witnesses or officers we would need to have for you to prove up the allegations in the petition and or an amended petition?
Your Honor, if I could have 2 weeks.
Ms. Singleton, was there anything you wanted to add in terms of Mr. Grimes' situation? I appreciate you helping get us situated so that we're going to try to address everything that Mr. Grimes might need to work through.
Not at this time, Your Honor. I'm just mainly on here in case there were any questions that came up
Okay.
that I
So
might have
Mr.
some
Grimes
information.
is now an adult. And your connection to the case is it ongoing supervision from the armed robbery case that was the SB 440?
No, Your Honor. Mr. Williams had contacted me to see if there was any information that I had or if there was anything as far as with his mom. So I had spoken with her. When he was initially released, I did help her initially with the probation.
Yep.
As far as making sure that he reported. So if there was any questions about his initial reporting, I would have been able to speak to that.
Got it. Okay. Mr. Collins, I'm still a little unclear as to the extent of your representation. You did get a hearing for Mr. Grimes today. He's very squarely on my radar, so his case will continue to move. It is unfortunate if Mr. Grimes has been in custody for as long as you described. I don't know if it's partly connected to the more recent entering auto allegations, but either way, he's entitled to resolution. Do you believe that you will stay with the revocation piece of things, or you may be done after today?
Your Honor, I believe I'll be done after today.
Okay, so then we'll need to figure out who will be handling Mr. Grimes's case going forward, because it may not be the public defender because of the Johnsons from the old case, but certainly it needs to be someone who is ready to wrap his or her arms around three things. This case, meaning the case that's on active probation, and then the two CP cases, because it might make a lot of sense to take care of everything in one setting.
Yes, Your Honor, I'm happy to facilitate to any individual I need to help connect and continue this going. But I was only hired for the sole purpose of this.
Okay, I appreciate you delineating that, so I don't volunteer you for things beyond that. And you and Ms. Harris can have that conversation away from the rest of us as to what's next. Mr. Williams, you will likely get more than the 2 weeks you're asking for, because we need to make sure we get an attorney lined up for Mr. Grimes. And we'll need to work through the various conflict situations that exist because of the case that's on probation, the case that you took the plea on. There's not a conflict with the two unindicted cases. And the PD, the Public Defender's Office, seems to have dived right in with both of those. So we'll need to work through how that's going to progress. Do you know, Mr. Williams, are the Johnsons also on probation now, or are they in custody? What's their situation?
They have custody sentences, Your Honor, so I believe they're still in custody.
They had a different outcome than Mr. Grimes.
Yes, yes, sir.
Were they juveniles at the time?
I believe one of them was, Your Honor.
One was, and one was just an adult, and I think one had a 10-year sentence to serve, and there might have been an 8-year sentence on the other one.
Okay, so they're out of the picture for the foreseeable future. That may make it less complicated for the conflict question. Okay, well, I think I know what we need to do. Mr. Grimes, you've been very patiently listening. Do you have any logistical questions? I can't talk to you about the substance of your case. That's what your lawyer would do. But do you feel like you understand what's next?
Yeah.
A lawyer, whether it's Mr. Collins or someone who is appointed to represent you, if your family cannot afford to keep Mr. Collins on the case, we'll be meeting with you soon to talk about what makes the most sense for how to handle the probate case, the case with the Johnsons, as well as your two newer entering auto cases. Okay? All right. Let me see. I think that is it. Mr. Williams, anything else from the state?
No, Your Honor. Thank you. Thank you for having me. Thank you so much.
Mr. Collins, I appreciate you getting involved. Please let Ms. Nelson know, that's my litigation manager, if you're staying on the case, because one of our projects is gonna be to engage the public defender's office to work through the conflict question. In other words, we're assuming you are rolling off the case. If that is not true, you need to let Ms. Nelson know, okay?
Okay, thank you, Your Honor.
All right, thank you. Thank you, Ms. Singleton. Great to see you. It's been a minute.
Take care, Your Honor.
All right, bye-bye.
Thank you, Judge.
Your Honor, that concludes all of my business. I just wanted to stick around in case you needed me.
I appreciate you sticking around. I always like having you around. How was the big trip?
It was nice. I worked most of it, but it was nice.
Still, you got away. That's good. Changing scenery can help.
I did. I'll see you in a couple of hours.
All right. Oh, yeah. I have a question about that. Are we going forward with Mr. Dunham? And if so, on what?
It's gonna be a long afternoon, Your Honor. But yes, we're going forward. I have both my officers there. Well, one will be on call because he had a prior appointment, but they'll be there. But we have a lot to get through. It'll be a long afternoon. I'm going forward, but it'll be a fight. So.
Okay.
All right. See you later.
Yes. So don't bring Mr. Goolsby out yet. We need to figure out where his lawyer is. Ms. Nelson, can you figure out if Mr. Franklin is coming in or dialing in? Because that was supposed to start at 10.
Let me see. Mr. Pinion, did you get in touch with Mr. Franklin just so that if there's an update that he might know?
I wasn't able to, Your Honor. I believe that he's under the impression that it's off for today. The motion to suppress identity was moved, and this other motion was also listed, and I just was here out of abundance of caution.
So as I understand it, there's a motion to suppress ID. We're not able to go forward today because
the officer's on vacation.
Okay, on vacation. Okay, but we'll do that sometime soon.
Yes.
You're able to go forward with a 404B, which I've read, doesn't require any witnesses. I don't even know if it's 404B. It may just be part of the chain of events. But either way, we need to have a hearing on it so that you know what's happening with it. You thought we might still be able to do that today, but Mr. Franklin may have thought, understandably, it's off because the detective's not coming in. So, Ms. Nelson, if Mr. Franklin is not prepared to talk about the 404B, that's fine. We can address it. It's not a complicated one, so we can address that when we reconvene on the suppress ID. But if he wants to do it now, we can do it now. 100%.
Okay, I'll reach out to him and give me a few minutes.
Great, will do. Thank you. All right, so we may not need Mr. We can bring Mr. Goolsby to the door if we're not going forward, so I can let him know, but it may be that nothing's happening with that, and then we're done until 1:30. Yeah. We're not ready for him yet. We got to track the word. Lou?
Hey, DJ.
Huh.
You called the wrong person.
Didn't know that was an option.
That's fine. Okay.
Let me see what it says on this funny piece of software. I didn't know blue was an option. So I can mute the others, like mine, I just muted. But the witness one, if I click the mute, it turns red here, but it flashes blue there. Does it broadcast? Did you tap on it? Makes noise. Well, I'll send the Dejuan an email just asking, what the heck does that mean? the speakers above the clear touch have the red bar on, which I think means mute, but everyone could hear everything. Is that part of your solution? Is that you have that off and it feeds through the FTR microphones, or you didn't do anything with that? That's not you.
Matter of fact, for some reason, the sound is not coming through. That's why I have another microphone.
I noticed partway through this morning, red, bad. Normally that's green. And I think if we mute courtroom, I think that just a Superior Court courtroom, but if you muted that one, I thought that made that bar turn red, but who knows? Yeah, people could hear, so.
Judge,
Yes, ma'am.
I'm not able to get in touch with Mr. Franklin. His voicemail box is full. He's not at his office, so I guess we can assume that he thought the motion was off altogether, so I can reset it.
Okay, let's do that. So Mr. Pinion, we'll see. I'm gonna tell Mr. Goolsby in just a second. I'm gonna bring him to the door and let him know it's being reset. But you're working with the detective to figure out a date that is good. It needs to be a Tuesday, because that way Mr. Goolsby can be here in court, and the detective can be here in court to do the suppress ID, or whoever you're calling. I mean, you may choose to call the person who made the identification, but either way, the witness or witnesses that you need to defend against, if you will, didn't realize I was off, sorry. The motion to suppress ID, you will let Ms. Nelson know when they can be available on a Tuesday, or at least you'll coordinate with Ms. Nelson.
Yes, I've been speaking with her about it.
Great, and then on that day, we'll also talk about the 404B.
All right.
Which, as I understand it, is basically another silver clown mask Waffle House armed robbery, which just happened to be in DeKalb, which is why it's not in your indictment.
Correct.
Okay, that shouldn't be a real complicated one to work through. Well, thank you, Mr. Pinion, for being available. I know I owe you and Mr. Franklin 2 other 404B rulings. We'll take care of that soon. And we'll see you whenever one of your cases is next on the calendar.
Okay, thank you.
Bye-bye. So if we can get Mr. Goolsby to the door, then we are down until 1:30. Well, you heard what the lawyer was saying. That didn't make me excited. Oh, what? Mr. Goolsby, how you doing? I just want to give you just stay right there. This will be real brief. I just want to give you an update since it is now real rare to bring folks over. You may have wondered what was going on. Several weeks ago, we scheduled this because we were hoping to be able to handle 2 motions. Your lawyer has filed a motion to suppress an identification. Someone allegedly picked you out of the lineup, and your lawyer has said there are problems with that. That requires live testimony, and those witnesses were supposed to be here today, but there was some conflict with those witnesses. There's another motion out there. The prosecutor wants to be able, if you go to trial, to get in some facts about a Waffle House robbery that was in DeKalb County. So you're not charged with that in Fulton because you can only be charged with Fulton stuff in Fulton. We thought we were still going to do that second piece because we don't need witnesses for that. That's your lawyer arguing and the prosecutor arguing about whether any evidence about this supposed DeKalb Waffle House robbery should come in. But wires got crossed. Your lawyer thought, hey, because the suppress ID is off, everything is off. And so he has other commitments this morning. But we didn't figure that out. So we got everyone here and you were already brought over. So it wasn't meant to just be an exercise for you. When you're brought over next time, it should be in a few weeks. It'll be on a Tuesday. That's when we are able to bring inmates to this courtroom. We'll do both those hearings. So there'll either be a detective or the person who claims to have picked you out of the lineup. And your lawyer will ask questions of that witness. The prosecutor will ask questions of the witness. You'll be sitting next to your lawyer. And we'll talk about the state's motion about wanting to get in stuff about the DeKalb Waffle House. those are the only motions left. Once I rule on those, we're ready, once we can get jurors in here to get you a trial. So that's why you got brought over. I'm sorry it was a false alarm, but we really intended to take care of some of the business. We'll get you back here as soon as we can. All right. So Ms. Crawford, hold on one second. Ms. Crawford and Ms. Nelson, we will be down until a little before 1:30. Mr. Dunham is here, he's in the building. Hopefully we'll get Mr. Franklin here a little before 1:30 and get going, since Ms. Hall has forecast that it will be a long afternoon. So I don't know what that means. It doesn't mean a short afternoon. I always hope they say, hey, we've worked it out, especially since Mr. Dunham has 3 cases. Be nice to take care of his 3. But it doesn't sound like it's gonna roll that way. So I will see everyone around 1:30. Thanks.
Okay, see you at 1:30, Judge.
All right.
And we'll just leave this exactly as it is.
One thing that we did figure out, I'll let you get moved.
Yes, thank you. Yes, it is nice. I mean, it's still a million boxes everywhere, but I'm out of my mother-in-law's basement. It's our space now.
What Ms. Harrington and I figured out is that the little microphone is what's picking you up. For some reason, this is working.
Yeah.
But you can hear it.
Yeah.
But when I turned off my microphone, they could barely hear.
Okay.
So when I turned on the microphone and turned it up, they were able to hear. And that does have the.
But you need to keep it here because it picks up stuff coming through there,
Right.
which is from everywhere else.
Right.
Okay.
If we had a monitor speaker that was just set up over here for the FTR system, I would need to put that.
Got it.
But
Okay.
the only way to get everything coming through the FTR system, because we can't really integrate it,
Yeah.
is just do it this way, pick it up through the speaker, and then let that be sent through.
Well, I think I told you this. We have been volunteered as the first courtroom to get the next thing, where there is actually, I don't know if you'll get one. I know there'll be a new computer here. There's basically they call it AIO, all-in-one on each of the places, and that integrates sound and video and all that in theory. So we'll see. Yep. You guys good? See you a little before 1:30.
Ms. Crawford, can you hear me?
Yes, I can hear you.
Okay, could you say test, test, test? I'm trying to check the sound system.
Testing, testing, 1, 2, 3. Can you hear me? Testing.
Yes. Thank you very much. I appreciate it.
You're welcome. Okay, I'm gonna go on pause. I was doing a little work. I'm gonna pause and step away until we come back at 1:30.
Sounds good. Thank you very much.
Thank you.
Yes, they, you know, how.
Well, let me know. I'm eat like me.
Testing 1 2 1 2. Testing 1 2. Testing 1 2 1 2. Testing 1 2. Testing 1 2 1 2. Testing 1 2 1 2. Testing. Testing 1 2 1 2. Testing 1 2 1 2. Testing. Testing. Testing, testing, 1, 2, 1, 2, testing.
Yeah, I doubt if they can do whatever they did, but you needed to be on now. Correct? The witness might, yes.
Testing, 1, 2, 1. Oh, that is on. Okay. Testing, 1, 2.
Hey, when Georgia here? Okay. Okay, thanks. Carl and 1B, saying, can we make it, he needs the microphone mic to work, can you undo whatever we did? The witness stand. But he said, was it flashing? Hold on, let me put you on the speaker with him.
It was flashing blue when I left the courtroom a while ago, and it was working then. It was just flashing blue. We did not know why. But we got sound out of it when it was blue. But yeah, you're right. It's not got any sound coming out of it on the screen.
So what do they do with the witness? Then if you can't, the mic ain't working, so we're trying to figure out. You.
I don't know. The laptop's not set up yet.
Yeah, everything's connected. I mean, this laptop?
Yeah, it's not plugged in. Internet.
Then how do I have what's up here? Yes, it is. This is the cable, this blue one.
The board is not plugged in.
Oh, where am I seeing that?
I don't know.
Why are we seeing what's on the? Oh, it's probably Wi-Fi. Okay.
That'll do it.
Okay, that's fine.
Feedback.
What do you mean? No, nobody can know that. Who is Crawford?
Lord, I let you on.
Okay. So what are you trying to say? I don't think anybody's on. So don't mute this laptop. Right. Click to join. It says click to join audio.
Testing.
Yep, major. That's fine. Yeah. Right. You do the laptop speaker itself. Testing. Echo and horrible. I'm gonna turn it down, man. It's got muted, so unmuted. Are your friends? I see you hi, yeah, I see Ted Michael, button one across. Oh, oh, yeah, I know. Okay. Testing, testing. Oh, I'm not on, hold on. Testing. Testing. 1, 2, 3. Testing 1, 2, 3. Still echo, too much echo call or what?
Oh, yeah. I'm sure that's saying is that what's supposed to be red or green?
Green. Yeah, George, the speaker on the clip got the green, not green. You're not aware of it, no?
What's that?
So you're plugged directly into that spot.
No. I've got a microphone in front of it, I'm not plugged into it. I'm not plugged into the computer, yes. See, this is.
That's it. You just plug it into like a microphone jack. But the filter is still plugged in. So was it working like this morning? Yeah.
Even with the red light on one.
I mean, the USB from the speaker mic is still plugged in, but it's great. So I'm plug it right in here. Yeah. So you don't use the press on, you use your system? That's the press on.
Right, I mean,
That's why that's red.
okay.
Okay, so. Right, it's the sound and the witness sound. What I mean, see, this is what I'm saying, I don't know enough about audio.
Well, I mean, we really can't do anything else unless you want to disconnect it down by the floor right there where it goes to the just jack.
For the what? I mean, there's nothing plugged into the laptop but the cable. Okay. No, I don't see, I'm not chasing what you're seeing, so I see some little gray wires under the table, under the desk. Oh, okay. Mm-hmm. Okay, so how does it pop out there? It's just the one, but there's two of them. You still there? It's just the one, but there's two of them. It's not gonna affect another one, is it? Both of these plug-ins over that mic. Oh, it's got a little on-off button. What you turn that on?
No, that's not.
Ah, good, that car, so, all right. Good, you like, what? Okay. Okay, so I'm gonna close that top one. That's running down, doesn't matter which one. Right. Okay, so now I'm gonna go back to the witness stand and try to talk. So now I'm going to the witness stand and talk, or I'm gonna plug it back in. Okay. All righty then. What the? I think the judge is aware of that between, he saw the email between him and Deshaun, right? George. Okay. Saying basically it's not working, so. Until FTR can balance the. You're gonna give it a few seconds, time to plug this back in.
I'm having the fun that I hear you, and I hear that.
Oh, even now?
Now you're not.
Okay. Okay, I'll plug it back in now, right?
I heard you echo.
Testing 1, 2, 3. Yeah, it's still green. Yep, I'm just getting the echo from up there. Where's the echo coming from?
You heard the echo too?
Yeah. So, what are we supposed to do for the witness? Testing. I turned it down, I just made it lower. Testing 1, 2, 3. So I don't know, Carl, what do we do? Okay, so what happens if I mute the laptop? We have nothing. That's where the sound's coming from. Testing 1, 2, 3. Couldn't hear me. Can you hear me, Carl? Still echoing, huh?
Yeah.
No, it's still echoing. No. It's still stuck on green. Came back to green. I know.
Good evening. Excuse me, it's me, Miss Crawford, on the screen.
Okay.
I was gonna say something to you. When you had your courtroom D witness stand muted, there wasn't an echo. I could still hear you, but there was no echo.
Oh, really? Okay, right then.
Yes, ma'am.
So you can still hear me now?
Yes, ma'am. And there's no echo.
What about you are talking to the clerk right now?
Ms. Crawford, does she sound better now?
Yes, I can hear her when she has the her mic muted. I can hear her and and there's no echo. But when she takes it off mute, the echo.
Okay, Gwen, count. Let's see if Ms. Crawford can tell the difference. Just start counting.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Ms. Crawford, did you tell a difference in that when she was counting?
A difference as in when she started out, it was low, but once she got towards the 9-10, it was louder, but I could still hear her without an echo.
Okay, that's what I wanted to find out is if she was louder as she got closer to the number 10.
Yes, she was louder towards the end.
All right, it's going through my microphone. It's not.
Okay. Is that okay? Should work?
Well, I mean, I think they'll be able to hear.
And you're getting the recording, I guess is my main concern. Did you go ahead? Did you go ahead?
You got your.
No. Yes. Oh. Yeah, it's a million of them.
You did. Okay, because I can leave that microphone turned up.
Okay.
And they should be able to hear the rest. She said she could hear us. We got to figure out why that's.
Well, something's wrong with the FTR speaker. And they have to come and figure that out, unfortunately. All right, George, I'm gonna let you go, thanks. All right, bye.
Mr. Franklin, would you speak into the microphone, please?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Ms. Crawford, did you hear Mr. Franklin just then?
Yes, I could hear Mr. Franklin.
Is he loud and clear?
Yes, he was loud and clear.
Thank you.
Say one more thing for me, Mr. Franklin, just so I can make sure.
One more thing, Mr. Franklin, just so I can make sure.
Okay, I can hear you.
What about the judge? Did this come out of here?
Good afternoon, everyone.
Good afternoon, Ms. Nelson.
Good afternoon.
Ms. Nelson, did you hear Gwen all right?
Good
Can I
afternoon.
hear? I can hear Gwen, yes.
Okay, loud and clear.
Loud and clear, testing the judge's mic.
Yes, yes.
Okay, thank you. All of this stuff.
I mean, this morning when I came in, so what we have is that little microphone. If I'm speaking to the base of the judge's microphone, a little take on to the judge.
Oh.
So, that's taking the sound of all the microphones computer. And one worry was my mic. I turned off the audio max. I assisted too. You would hear it. It's actually my. Because it's my good mic that's speaking. that in just before it's plugged into the computer. Plugged in the tree. That makes it go up. So just do it. So that should be
Okay. I think it's working. From the witness stand, so.
Oh, you got that thing? Oh,
No, we didn't get it to work, but we got Charles Mike is over there and it's allowing him
okay,
and everyone on the call to hear.
great.
And thank you.
We'll see what happens.
Email us to go crazy, just keep my phone.
We will.
Thank you.
I'm not sure if they did much, but they got the green light to come on, and when they did, the microphone was working.
That's, what Mr. Injuri told me. I got the blue light off, but it's still not doing it.
That's what I told Jordan, said, microphone was actually working on the blue light. So it's not.
Right,
It's not working.
semi-progress.
Council and everyone should be able to use their microphone. No trouble. It's just, I've got the little mic of mine over here turned up. So,
Okay. Is, Mr. Franklin back in lockup with his client?
Yes.
Okay. Not a problem. I just got out here and we were getting things semi-working. Well, Mr. Franklin?
Good afternoon, Judge.
So, Mr. Dunham is here, and we can bring him out in a minute. I want to understand what we're doing and not doing. I know there are a few motions, suppress ID, suppress statements. There are a few witnesses, one of whom Ms. Nelson tells me is maybe at the ER or the hospital right now with soon to expand family. So why don't I start with you, Ms. Hall, just letting me know procedurally what you think we can get done today and whatnot. I'll hear from Mr. Franklin, then we'll get Mr. Dunham out here and get on the record.
Thank you, Your Honor. So I don't know where to start. We have a discovery issue in this case.
And I'm sorry to interrupt you. Mr. Dunham, of course, has 3 cases.
Oh,
So when we're
alright.
talking about this case, we're talking about the one on the calendar? There's
Yes.
only one on the calendar?
Yes, Your Honor.
Okay,
The aggravated assault case.
back in July, I served on defense 911 calls and, I believe 15 body camera videos.
Wow, I mean, there were 15 officers, or it was just one officer who?
Well, no, there were several officers. I believe maybe more like 8 or so that came out because it was an actual shooting.
Oh.
And someone was shot, but there were some officers that had multiple recording. Yes.
Okay.
I was told by APD that I had everything. I did know that I didn't have the interview. I didn't know interview existed, and I knew that I didn't have it. So I've been inquiring. The person that had this case before me also requested this stuff, and we were told that we had everything.
So Mr. Dunham was supposedly interviewed by police?
Yes.
Okay.
When I was listening to.
And would it have been a body cam interview or
No.
go down to the precinct?
At the precinct.
Okay.
When I was listening to jail calls, and I do also know that there was a lineup done, but I never knew until last week that there was an actual interview, not just a statement that was made by the victim at the hospital, which is kind of the way the report reads. But there was an actual real administration of the 6-pack done. Although she was familiar with the defendant, there was an actual administration. So while trying to get prepared for this motion, I learned that those 2 videos, which there's one for the video for the defendant interview, and then there's the victim's interview.
And it's during the victim's interview that you believe there would be a recording of the identification procedure?
Yes, yes.
Okay.
I mean, obviously, I can still have the officer testify as to what he did procedurally, but the actual video, APD is having issues locating either of these videos. The officer, as you know, last week I wasn't even in town, but we spent hours trying to deal with this over the phone and try to find ways to locate it because he knows they exist. He did not administer the 6-pack, but he was a lead investigator, so he pulled the officer that did do it, and he was the person who actually talked to the defendant, and the defendant made the statements too. So when I say that we have discovery issues, we're here on a motion to suppress the statements of the defendant, but we don't know what statements he made, other than the few statements we do get on the side of the road when he's initially arrested or detained. But we don't know.
So he could confess, he could say some things that you might not want to come in, but the defense might want.
Essentially, yes.
We don't know what's said. Okay.
Other than what my officer has told me, but he can't remember everything that was said during the video or during the interview. We've already discussed the issue with my officer Sutter, who had the emergency, and but other than
Is that the officer who supposedly did the interview, et cetera?
He did the 6-pack administration.
He was dispatched to the hospital.
He came in a couple of days later when she was released, and she came down to the precinct and he administered it.
But he's not a case agent?
Not at all. Didn't know anything about the case.
Okay.
So he was my emergency officer today.
I'm sorry, may I interrupt for a second? This is a bit more substantive than I thought it would be. Is it okay if we go ahead and bring my client out?
Yeah, we'll get it all on record. I just want to.
Yeah, and I'm sorry. I know I'm long-winded. I just wanted the judge to know everything because, I mean, like I told you this morning, it's a lot.
Yeah.
So, I mean, it's a lot of things that I didn't know that I had or didn't have.
What's the name of the lead investigator?
I'll spell it. His first name is Nick. Last name is Garavaglia.
Okay.
And the lead investigator isn't the person who's told us we had everything. This was actually open records, which the investigator assumes that everything he did was in evidence.com, which
But Garavaglia would have done the interview of Mr. Dunn.
Yes.
Okay.
Yes. And he was the lead investigator out there when the incident actually happened. But just to bring around full circle, Your Honor, there GSR, I'm sorry. So I was listening to jail calls, and I heard during jail calls that about the dusting of the fingerprints. It wasn't vaguely mentioned in the report, but when I heard on the jail calls, I couldn't get in contact with my investigator, but I found a cell phone number on the system, contacted him, and found out through that conversation about all this additional stuff that we should have had that was never given to us, and we told that we complete discovery was given. But I did send that also to Mr. Franklin this past week, way past the scheduling order, that's come and gone. But, so I think that's the gist. I think I mentioned everything. The issue that, I think we have today is that one officer obviously isn't available because of the emergency, but then my second officer, he did have a scheduling issue when this motion was scheduled. I assumed, that during this time right now, we would be handling the motion to suppress, and I wasn't, and it's my miscommunication. I talked to Ms. Nelson about it, but I wasn't sure that we were having the actual Jackson Deno motion today. And that's no fault of nobody's. I assumed that would be closer to trial. So I told him that he could be on call while we dealt with this motion to suppress the ID, and that his may not even be important based on whether you keep things in or out of the discovery that we have and haven't given. So I told him I would call him and let him know, even though he's in his appointment now. So that's why I asked if we can have a reset to the entire motion so that he's actually available to come for the Jackson Deno, but then Mr. Sutton, whenever his situation.
And Officer Sutton, do you have, and thus does Mr. Franklin have, the six-pack lineup?
He has it now. I just gave that.
The six one?
Yeah, all those emails I sent yesterday or the day before is in one of those.
But that would be a recent development.
So yes.
So what you don't have, and thus Mr. Franklin doesn't have, is the video of that. But Mr. Franklin may, if he looks through a flurry of emails that he would have received in the last 24 to 48 hours, is what, a picture of the six-pack or each of the six photos?
Each of the six photos, and the ammunition, all that was included.
The ammunition?
Yes.
Okay, all right. Mr. Franklin, we can bring Mr. Dunham out. We obviously need to sort out where we're going next. Anything else procedurally I ought to know before he comes out?
Only that I filed a deficiency notice back in July.
Okay.
The discovery was due June 26th per the scheduling order. I'm not gonna file those like the day after, but it's.
No, I appreciate that.
It's been 3 months. So.
Keep your powder dry. Okay, well, we'll talk about what to do with what's missing and all that we did flying out here. So let's bring Mr. Dunham out.
Thank you, sir. Ms. Crawford, Ms. Nelson, I've moved my microphone. Can you hear me from the table?
Yes, I can. Did you hear me?
Yes, ma'am. I'm sorry.
Oh, okay.
Yes, I can hear you also.
Thank you.
Sorry, am I too loud? Because you
No,
know. I have
no, you sound great. We love hearing your voice. It's just funny because it usually takes you about 60 seconds to unmute.
Because I'm working on several devices, so I forget which one I'm using.
Very complicated out there in the woods. Ready? Okay. We're gonna go on the record now in 19 SC 172707. This is one of 3 cases that Mr. Dunham has. And this case is on the calendar today to work through 2 motions to suppress that Mr. Franklin has filed on behalf of Mr. Dunham. There was a motion to suppress ID and a motion to suppress statements. Ms. Hall is here for the state. Good afternoon, Mr. Dunham. I'm okay. How are you doing? You're making it. Glad to hear that. Mr. Dunham, I was chatting with the lawyers before we had you brought out here so I could understand what they were expecting that we get through this afternoon and what we might not be able to because of some things that have come up. And it sounds like we will not be moving forward on either motion. Some for good reasons, good's the wrong word, but understandable reasons, a family emergency for an officer, et cetera. And others, I think are going to be the basis of a conversation we need to have that I think your lawyer will lead about what to do with any evidence in this case about identification, as well as statements you may have given to law enforcement. So, Mr. Franklin, as I understand it, as you sit there today, you do not have recordings of any statement Mr. Dunham gave to law enforcement other than what might be on body cam.
That is correct. There's body cam video of he had pulled up to a house. Officers were kind of at the address already, and there's conversation there. That's part of what I would have asked to suppress, but there's this other actual interview that I have no idea what was said in that. There's also the other half of the statements to be suppressed.
Got it. Was the interaction between your client and law enforcement outside this house something that you would construe as custodial, so you have a basis?
Yes.
Okay. All right. And Ms. Hall, what witness or witnesses were you going to use? Is this the officer who has a conflict, not the family emergency officer, but the conflict officer who would be able to address the body cam part of things? Or was he going to address the interview at the precinct, if you will?
When you say body cam, are you meaning any statements that were made that might have been on the body cam?
Correct.
Yes, he would have been a part of that as well.
Okay. And that was Garavaglia or a different officer?
That's it.
So the body cam footage, if I were to review it, may not necessarily be Garavaglia's body cam, but it is Garavaglia asking questions of Dunham.
No, so the body cam that you watch would be of Officer Garviana's body cam to asking Mr. Dunham questions.
Okay.
So it would be his body cam.
The two parties to the conversations that happened outside this house that Mr. Franklin referred to were Mr. Franklin's client, and I'm saying Garavaglia. I'm not saying that's the right way to say it, but we'll say Detective G.
Yes, Detective G, and there was another investigator as well that was there. He was not wearing a body cam though. So all the footage that we got from that particular location was from Investigator G's.
Okay, so Investigator G could lay the background, lay the foundation if it can be laid for the footage, et cetera. He's just unavailable right now.
That is correct.
But Mr. Franklin has those materials and has had those for a while, not just 24 to 48 hours.
Yes, he's had.
I believe that date was July 24th.
Okay.
Around that time. So.
All right.
Now, to clarify, Your Honor, this case was before me, and I did speak with the prior ADA who said that she had served all these same videos. She did confirm that she didn't have what I still don't have.
Okay.
The interviews.
That's fine. I'm okay with the timing of the delivery of the body cam video, given where we are right now. That is something we can work through. We're going to sort out today how we're going to handle the non-delivery, the non-discovery, if you will, of the precinct interview. All right. In terms of the identification that was purportedly made of Mr. Dunham, that was made by someone that you contend, Ms. Hall, already knew Mr. Dunham. In other words, it's not a stranger on stranger identification.
That is correct, Your Honor, and not that they were friends, but frankly, the same location.
Okay,
So-
I didn't say friends, just that I would know this person. I see him here all the time, or that's old Cleve. I don't know his last name, but that's what people call him.
Yes, Your
Okay, got it. And you have provided in the last day or two to Mr. Franklin the components of the lineup.
Yes.
And the person who presented the lineup would be Officer Sutton, he of the family emergency.
Yes.
And it's your belief that Officer Sutton's interaction with the witness. Is the witness also the alleged victim?
Yes.
The
Well,
person,
there's a separate witness as well, but yes, the victim is also the witness who makes the identification, if that's what you're
the person who was shown the six-pack
is the victim.
is the person who got shot.
Yeah.
Okay. And that was filmed, you believe, and it would be Officer Sutton who would have filmed it, or is there someone from Tyler Perry Studios who was there?
No, so it's just already set up inside the room. Investigator G would have orchestrated that.
So the witness came down to the precinct. It wasn't that Sutton went to her.
That is correct.
Okay, got it. So it could well be in a drawer somewhere as both the interview of Mr. Dunham and the recording of the identification.
To be clear, Your Honor, it's not a situation where it was pulled off and it was lost by APD. It's a situation where APD transformed systems. Back last year, they had issues with their system. They have since created a new system. Because of that system, they have lost a lot of interviews that were taken in that floor, on that particular floor, which is floor 3 or level 3.
Okay.
So it may still exist. They just can't figure out where it went in the shuffle of this new system.
Okay.
So everybody is hands on trying to find it, but it may be a situation where it existed and now it doesn't. But didn't want to make their representation because they're not sure if it doesn't exist anymore. They're trying to figure out where it could have bounced to.
And I don't mean to characterize it as lost. I mean, it's effectively lost, whether it has been written over or discarded, or it's in a folder that says Defendant Jones instead of Defendant Dunham. For Mr. Franklin's purposes, it's lost because you can't get it to him. Okay. What is the last name of this supposed witness who identified Mr. Dunham through the six-pack?
Miss Ikea, sorry.
Arnold.
Yes, Arnold is our last name.
Arnold?
Arnold. And I was just gonna say, Your Honor, I know the idea is a two-part test. I would have had her here if, in case the first part fell through, or I'm sorry, was ruled not in our favor. But she has since been shot again and stabbed since this incident. So neither APD, who is still dealing with her in cases, nor my investigator or my office have been able to locate her since these new injuries have happened.
Yikes. Okay. Well, I'm sorry for Ms. Arnold. So Mr. Franklin, my thought is, and I'll let you expand on this and make the record you want to make, is, well, why don't you tell me what you think ought to happen in connection with your two motions in this case for Mr. Dunham?
As it pertains to the motion to suppress identification, as I stated previously, the deadline, I believe, was June 26th for discovery. I filed my deficiency notice July 17th. It's been over 2 months, about 2.5 months since my deficiency notice. And I checked my email once Ms. Hall told me that she had emailed it yesterday. I could see that there's a bunch of emails that I received. I guess it was last night or this morning. I think that, I don't want to say I showed grace, because it's not I'm in some position of power to show grace, so to speak. But I think deadline should have some kind of meaning, some effect. I'm not giving some absurd argument about the stuff that was served shortly after I filed my deficiency notice. Only those things that, after our conversations yesterday, that I was not in possession of. I did receive, correct me if I'm wrong, Ms. Hall, maybe Monday or last Friday, the GSR report.
Friday.
Okay, so very recently I received that. I would still argue for the exclusion of the GSR report, the evidence pertaining to that, the photo lineup identification, which we would be able to address today, well, would have not been able to address today. because the stuff that I was been given last night, and I was not been prepared to go forward with it. So we're at a point where things are being, from Mr. Dunham's position, unfairly extended in a way due to the negligence of the state in all of its arms, not necessarily the DA's office, certainly not Ms. Hall herself who came into the case in the middle of everything, but through the police, who, okay, you change computer systems, but you have had these several months, and I know Ms. Hall has reached out several times and said, hey, where is it? Hey, where is it? Hey, I need it. And you don't find it until the day before a proposed motion. I just think that it's not fair at all to Mr. Dunham. As you mentioned before, he has several cases, he has 3 cases. We were actually prepared to plead the possession of a firearm case before we learned of this case. So that case is largely done. The aggravated stalking case is a older case from 2016 and 2017 that only came about after this indictment for the shooting situation. And so the impact has been that waiting on evidence in this shooting case has affected the ability for me to negotiate a global resolution as it involves the other cases. Because if it was not him, then we likely would have been able to get a reduction or even a dismissal and proceed with the probation plea that we had for the possession of a firearm case, and then figure out if we want to attack the stalking case or try to wrap it up, because again, it's very old and dated. And at worst, in my experience, I would think that it would be a probation-ish offer, especially being that he's been in custody 226 days this time around. I saw you look down, he got out, was on bond, was reporting on bond, had an ankle monitor. And once the aggravated stalking case was indicted from years before, was rearrested and has not subsequently been released because of the older case. So he's only in custody on the stalking case, not for this actual shooting case, because at the time that we had the bond hearing with Judge Reeder, there were issues finding Ms. Arnold at that point in time. There were issues about identification, of course. So we were able to secure an ankle monitor for him. And so Mr. Dunham has suffered in that the ability for us to engage in meaningful negotiations has been affected by this delayed discovery.
Okay. What about the motion to suppress statements?
As it pertains to that, I did receive the body cam footage. I believe I said it was July 24th, give or take a couple days. I'm not jumping up and down about having that one excluded. From my recollection, I haven't watched it again in a minute, but I believe it's pretty clear that once he gets out of the car, the officers just start talking to him. And certainly, I believe they got to the location because there was information on a license plate or a tag. They found the address, went to the address, waited, pulled up.
This is all in connection with the shooting?
Yeah.
It wasn't a coincidence that they were looking for Mr. Dunn?
Correct.
Okay.
They were there looking for him intentionally because I think, if I recall correctly, the license plate information they had brought them to the scene.
Okay.
And so he certainly was not in a position we would have argued to leave because this is a tier 2 investigation at that point.
And you don't need to argue it
Yeah.
now. It sounds like you've got the body cam footage and you'd be prepared if we get that, if that is admitted into evidence for purposes of the suppression hearing, to argue what you want to argue as to why it ought to be excluded if this goes to trial.
Yes, sir.
But what you don't have is anything about Mr. Dunham's interview with Investigator G down at the station house. Is that
Correct.
correct?
Correct.
Even a waiver of rights? There's not anything like that?
No.
Okay.
The other thing, a passing comment that I'm gonna address that Ms. Hall made, she made mention of her predecessor having said that she had given certain things before. That tends to be the answer about everything that Ms. Hall does not have. Ms. Hall will say, I don't have this, I'll talk to such and such about it, because, she inherited cases from somebody else. And whenever there's not something that's been filed in discovery, or we have a question about, no, I don't think I got that. Literally everything this person says is, oh no, I gave it to him. Not a particular memory or anything, just, no, I gave it to him. So I had not received the body cam, from my understanding, before the date that I had, that I just mentioned, the July 24th or so date.
Okay. I'm recalling different scenarios across the many cases where,
and those are not things I'm saying about Ms. Hall herself, but when she is inquiring with whoever had her case before her,
that person will say, no, I gave it to you.
Yeah.
Your Honor, can we be clear today that there was a practice of giving discovery where that person never filed anything, ever? It was just handed over in court. So that is always the case, because these cases are from 2019, so should have been already served. Just like in this case, I was told by her that she didn't have the interviews, but that she did serve body cam and jail calls. But Mr. Franklin doesn't have that stuff, so it puts me in a position. And it's the state, because we should file everything and then we'll cover ourselves. But
You are relaying what you're told, and that makes sense. If you talk to Ms. Iqbal and she said, I gave X, you ought to tell me that. And then Mr. Franklin's gonna say, I don't have it, I didn't get it. There was at least one certificate of discovery filed by Ms. Iqbal in December of last year, about a month after the indictment, indicating that she provided Mr. Franklin with the indictment, witness information / statements. Is that the body cam video? I don't know. It doesn't say exactly. Other warrant, citation, recidivist notice, and police offense report. That isn't as explicit as it's the body cam video.
that would have just been, Your Honor, to be handled. Yeah,
Just
that would have
standard
been,
packet?
what our legal assistants would have filed for, before we even get to court for the case.
Okay. So that doesn't resolve it. But either way, I understand that there are, it sounds like you found the same thing in April. You may have just been coming behind Ms. Iqbal, but you have a.
Oh, yeah, I like to, because I don't like this, so I try to sometimes go back and read everything, but then I found out that that's a lot of work, so then I stopped,
So, Mr. Franklin, what is the remedy you're seeking in light of what appear to me to be discovery deficiencies? And the reason why sometimes matter, I don't see this as one of Ms. Hall not doing her darndest to get those materials, but the end result is the state has not provided Mr. Dunham with video of his own interview at the station house, and the state has extremely belatedly provided the 6-pack, and that's all that you got. You did not get the accompanying video, which would have been in some respects the best evidence of how did the identification procedure work with Ms. Arnold. And you don't have that because Ms. Hall doesn't have that, not for want of trying. So what do we do with that?
All right, so I think there are a couple levels of kind of what I'm asking for. So in my notice of discovery deficiency, I may mention 6 things. I'm not sure if you have a copy of it. It's something that you can access.
I will look.
Just to kind of check it out.
There it is. So you filed that, and then there have been 4 supplemental certificates of discovery since then. The body cam videos, July 24th, 911 call 2 days later, and then a few other things, but not what you're looking for. Okay. So I'm calling it up.
And so the audio video recording of the interview, so that would be both the interview of Mr. Dunham and the interview / identification of Ms. Arnold. We would ask that any and nobody's view of the fact, do I have those at this point in time? So we would ask that those, any statements or reference statements that Mr. Dunham made while in custody be excluded.
In custody at the station house, as
Yeah.
opposed to outside his car and the house?
Yeah, that's a different level. I'll get to that.
Okay.
So exclude the statements from when he was in custody at the station house, interview or reference to those. We would ask for the identification for which we've only received the physical lineup in email within the last 24 hours, but we have not yet received. I guess the admonition is part of what you sent yesterday. So we've not yet received at all the interview of Ms. Arnold during her identification. So we would ask that being that the video would be probative of how the interview was conducted and the propriety of such, we would ask that that be excluded as well. The second thing listed is the copies of the six-pack lineup by Ms. Arnold. So I mentioned that we're asking for exclusion. That's the kind of encompass. So reference to the fact that he was identified at that point in time. I understand that if she has a personal history with him, that if she comes to court and says, that's the man, that's based on something different than the identification. So we would ask that the identification at that time be excluded. I received surveillance video. So I've had a chance to view it once. I haven't watched it several times. Obviously, Ms. Hall attempted to serve it to me on Friday, but it was a link that only works for her. So she rectified that, and I've had a chance to watch it this morning.
This is the Mr. Bill's Wings surveillance video?
Yeah.
So you have it now?
I don't physically have it.
Okay.
But
And that's not something that is suppressible. It might not be admissible at trial because it's not relevant, but that wouldn't be subject to suppression.
not suppression, but we believe that because it's a discovery, non-compliance with discovery, not trying to provide a certain date that it can be excluded as a sanction.
Okay.
I'm not sure if there are any photographs that were served.
No, they weren't sorry, but they are.
No, I'm saying that they were in the subject email. Yesterday.
They weren't.
Okay.
They weren't, but they're on.
This is the situation that you're running into in every case, that for some reason, if crime scene technicians were brought out to the scene and took photos, this quarantine has prevented them from doing digital work.
Well, I've been told, Your Honor, from several sergeants now that that lab is closed and we can get, no one has special permission except for the sergeants to get into them. The sergeant I spoke with this morning, he actually went and talked to another supervisor to try to get access to the ones that we have for this case. And he was able to send them, but in general sense, they're closed unless we call and, the judge said we need them. We gotta have them. But he said even with that, it's still a process. It's still, they can't just walk over there and get them because they're actually closed down.
Okay.
So that is something that he literally emailed to me as I was walking into the courtroom. He was able to gain access to those because they're already on evidence. So I can't explain how they upload and keep things, but
Understood.
Those are already on evidence.com, so they just need a special permission to actually give them to us.
So you have now crime scene photos?
I now have them, yes.
Okay, that you can share with Mr. Franklin?
Yes.
Okay. And you won't let the link expire?
No, I'm gonna forward it. I was literally walking down here, we were on the phone, and he said that he was able to get that permission.
Okay.
So to the extent that those just provide context that is neither particularly harmful nor helpful, I don't have any particular requests as to the photographs, the crime scene tech reports of any. The gunshot residue testing we did receive Friday or yesterday. Maybe you said Friday and I opened it yesterday.
Is that from the GBI?
Yes, that's from the GBI.
Okay.
Because it was not compliant with the discovery request and served 2 months after I filed my deficiency, we're asking that that be excluded pursuant to the case management order.
Okay.
And similar request of the results of any testing performed with defendant's clothes. I think I wrote that because I may have read something that they mentioned they tested clothing, but all I have now are gunshot residue results. So unless it's part of what was emailed recently, it doesn't, I don't know if it exists. So to these, unless it would end up falling under Brady type stuff, we would ask that the state's use of such evidence be excluded.
Do you know, Ms. Hall, if there are clothes of Mr. Dunham sitting at GBI to be tested for anything?
They did collect his clothes. They are at GBI. They were not tested with the powder of his hands or the residue from his hands. Yeah, so they're there. They did not test it.
Okay, and you don't intend to have the GBI do anything with the clothes?
I didn't intend to have anything done with them, other than me using them if we went to trial.
Using them,
and just presentation, just as
oh, here's the red shirt.
right.
Someone said
That's
that.
it, yeah. So other than that, no, I didn't.
So right now they're basically just the custodian of the clothes, but they are not expected by you to perform any role other than holding on to them until you would need them for trial.
Correct.
Okay. All right. So Ms. Hall, well, let me make sure, anything else, Mr. Frank? You've gone through the list of 6 from your July 17th discovery deficiency.
Nothing further.
Okay. Ms. Hall, anything you want to say in response? I mean, you sort of started the conversation by providing a very helpful background as to efforts you've made and maybe some efforts that law enforcement has made to track things down. You've heard what Mr. Franklin believes ought to happen as a result of where we are and where we are not. Anything you want to add?
Yes, Your Honor, I do. I will respond to the surveillance, the exclusion of the surveillance. Any type of state sanctions or anything given to the state, there wasn't anything that was bad faith on our part. It's, even though we know that we knew, as in the state as a whole, knew that this video existed, there wasn't something we were intentionally holding from the defense. This was never a case that I thought that I didn't have it. I thought that I had everything in the case. And so when I'm being told by the people who administer or hold on to the evidence that this is everything, I do have a report that says different, but when I can't get in contact with the officer to confirm or deny or give me any type of additional information on that, then that's just us a working process of trying to get it. But as far as that surveillance, that was something that the officer what did have in his actual file that he had with him. I've called him several times through this whole, before even the pandemic started, to try to get this evidence. I sent him an email. I've even called the agency. It wasn't until I actually got a personal cell phone number from him and sent an entire book that I got a response back, and I was on vacation when that happened. And, I still was trying to figure out how we can still get everything, and I knew where we were at with it as far as it maybe being suppressed, but I still wanted to try to get as much as I could before we got here today. So as far as the surveillance, that was definitely never a bad faith on the state. Even with the officer, that was more so a misconnection, or I can't even explain what that would be, because he said that he no longer has that work number that I was calling. And the agency would say that he works second or third shift and that they would have him call me, and that never happened. But as far as the interviews, Your Honor, I don't have an explanation as to where they are. It is what it is. I try my best to get on, even taking personal time to try to get those 2 interviews, because I know how important they are. But that is what that is at this very moment. But as far as everything else, I would like for you also to, I want to mention the jail calls, because I was told that they were handed over. And so I've never attempted to give those because all I've done is listen to them because I thought that they were given. And I know that wasn't mentioned as one of the 6, but I do think that they're important and they are valuable to the case, especially for the state. So,
Well, they haven't been listed as a deficiency, so
Right.
that's not something before me. I don't want to play games with it, though. Mr. Franklin, am I gonna see a deficiency notice for jail calls soon? Have you been giving them on a fairly regular basis?
The jail calls were given at the same time.
oh, you got,
I think, hold on.
I just wasn't, you didn't mention it and I didn't want to resend because, I like to resend stuff and then it'd be an issue. So I just wanted to go ahead and mention it and deal with it.
Okay, I don't have it in my file here. I didn't list it on my discovery division because it's not something typically that I request.
Right.
It's not some, and it wasn't, the things I listed were things that I gathered from reading the report that I had a reason to think were meaningful, so.
Got it. I'd make sure that Mr. Franklin gets a set. Jail calls have a way of popping up on the eve of trial. I mean, the reality is if a call is made on the eve of trial, you could not have had it before then. Obviously, you're talking about calls you've already listened to, so you've had them for a while. It's not on my radar to rule on. And I appreciate Mr. Franklin not jumping up now and saying, well, add that to the list. He didn't put you on notice that that was going to be something we discussed. You can inoculate yourself to a certain extent by sending them. In your mind, it may be, again, I'm not saying you didn't send them before. Your certificate of discovery for the 15 body cam videos does not list jail calls?
Yeah, I never.
Okay.
I know.
Yeah,
I've never sent them because I always assumed that they were. I was told that they were sent, so I try not to go back and do it again.
Good.
That's a lot for especially that particular job. So I just listen,
Okay.
and then when I will find something, then I'll have a conversation. But other than that, I didn't resend that.
Well, and you can provide the calls you're going to use. You can say, here's 97 hours of calls. You and Mr. Franklin appreciate a professional relationship. So talk to him about it. And he may say, just send me the ones you're going to use. I also don't want to listen to 97 hours. He has an advantage you don't, in that he can talk to Mr. Dunham. Are there calls I should be worried about? Oops, yep. Whenever I talk to so-and-so, I probably shouldn't have talked to so-and-so. And then he can work with you on how to get those. Okay. Well, here's what I'm going to do, and I will memorialize this in a written order. But if we work through the 6 items that Mr. Franklin identified, and this was back in July. First, his first one says audio video recording of the interview. I'm going to treat that, I'm not omitting anything. I'm going to treat that as law enforcement's interview of Mr. Dunham at the precinct APD HQ, wherever it occurred. So not at a scene where Mr. Dunham just got out of his car, but the organized interview that was recorded, not with body cams. And that I am going to exclude. I find that its non-production thus far in the process has prejudiced Mr. Dunham in his preparations. Mr. Franklin could not prepare meaningfully to argue a motion he filed many, many months ago. Everyone was aware that Mr. Dunham had been interviewed at a precinct and that it was recorded. We don't know how he was Mirandized, if there's a written waiver, et cetera. And we know none of this, I guess I should say most importantly, if Mr. Dunham said anything incriminating. It could be that Mr. Franklin watches the video and says, actually, I moved to exclude it because it's not relevant. There's nothing said that it relates to it. But he can't make any of those arguments because he doesn't have the video, because the state writ large has not provided it. And I do find bad faith, not on the part of Ms. Hall, I want that to be very clear, or indeed anyone with the DA's office, but it just doesn't cut it to have as the explanation, we had an old system, we got a new system, and that makes it hard to find the interview. That could be a true statement, but over the many months, the interview needs to have been found. It's a small request that's made, and I appreciate it is made by dozens and dozens of defendants, but each one has a right to his or her own interview. So that is excluded with the following caveat. If it's found, it should certainly be disclosed. And Mr. Franklin would have the opportunity to use it if he wants, if he finds that it's exculpatory. But that carries with it a burden. He doesn't get to play just the parts he likes. He may decide it's worth it to play the whole thing, assuming it's all admissible. If there are constitutional violations after a certain point, such that that part wouldn't come in at all, that doesn't come in. But if you find it, Ms. Hall, you do need to provide it to Mr. Franklin. And Mr. Franklin could petition me to revisit the exclusion of the video because there may be parts that he wants to play. And we work through, well, you know, Mr. Franklin, if those are coming in, rule of completion 106, these other parts might come in as well. And then Mr. Franklin's in the better position right now. He can say, well, I just assume none of it coming. And it really doesn't matter how constitutionally valid the interview was. It's not coming in for wholly outside of Fourth Amendment reasons for what I just described. So that's the first one. The second one, the six-pack lineup identification. That is also being excluded, and that would mean no mention of the six-pack, no effort to introduce the six-pack, and no use of the interview of Ms. Arnold if that interview is found, at least insofar as that interview relates to the showing of the six-pack and Ms. Arnold's purported selection of Mr. Dunham. Now, if the interview is found and there are parts of it that have nothing to do with the identification, it may be that the two sides agree that that could be used. And Mr. Franklin might want it to impeach Ms. Arnold if and when she testifies. But absent a request from Mr. Franklin, if the interview is found, it does need to be provided, but it won't be played. Do note that it sounds like there is an independent basis for Ms. Arnold to come into court and answer the question, do you see the guy who shot you? And she could point to Mr. Dunham. One would be, presumably she was there when she got shot. But two, it sounds like there is another reason for Ms. Arnold to know Mr. Dunham. And if a sufficient foundation is laid, then Ms. Arnold could attempt to identify the person who shot her in open court. But the state should not be asking Ms. Arnold, did you identify him on a separate time when law enforcement asked you about it? That would stay out unless Mr. Franklin decides that there are reasons to impeach Ms. Arnold about that. And we need to have a conversation outside the presence of the jury. But that is similarly excluded for the same reason. I don't find any fault on Ms. Hall's part, or indeed on the district attorney's office's part. It is, again, I guess, a transition from an old reporting system to a new one, a problem that should have been foreseen by the Atlanta Police Department. Surveillance video from Mr. Bill's wings. I'm going to allow that to come in if it's otherwise admissible. In other words, I'm not excluding it for discovery deficiency purposes. It's late, but it doesn't strike me as the kind of thing that would have been a subject of a motion to suppress. And unless Mr. Franklin wants to, when I'm done talking, articulate another reason, I don't find the defense is particularly prejudiced by it. It is late, but trial in this case is not going to be right away. And I think that Mr. Franklin would have time to construct whatever defense arguments or theories of defense he wants to combat whatever in the surveillance video. It's a non-speaking witness just recording what was seen at the scene. The crime scene photos for now are coming in. You just got them, Ms. Hall, so we'll let Mr. Franklin see them. If he wants to renew the deficiency concern, we can have that conversation, but I would put those in the same category as a surveillance video. It really ought to have been disclosed before, and there ought to be teeth to the whole discovery deficiency process. But I find things like a defendant's own statement to be much more in the channel that we ought to travel when we're working through discovery deficiencies than things like photos, which are important, but they show what they show. There's no nuance to it. It's going to be a photo of a shell casing on the ground. And there is ample time between the next few days when Mr. Franklin will get those photos and whenever this case might go to trial, for the defense to adequately prepare to address whatever those photos show. Similarly, with the gunshot residue results, that was either going to say yes or no. There was going to be the presence of GSR or there wasn't. What does the report say?
That there was.
There was. Okay. That's not a happy development necessarily for Mr. Dunham, but the universe of questions that are asked of a witness who talks about the antimony and the arsenic or whatever the elements are, those questions are there, and Mr. Franklin probably could do that cross-examination right now. It would be better if the defense got it sooner, but we're adding a whole other layer of lack of control by the DA's office because it's the GBI. And I didn't hear anything that suggests that you, Ms. Hall, were sitting on the report for 6 months, but that you recently got your hands on the report and handed it over. I'm reluctant to exclude something that is the result of GBI taking the time that it takes, as long as it's not on the eve of trial, which it is not. Finally, the testing on defendant's clothes. Ms. Hall has represented on the record that she does not intend to have the GBI do any testing. They are basically the custodian of the clothes for right now. They'll get them back to the DA's office at the appropriate time. So really the only issue with that would be if Mr. Franklin wanted an expert to do something with the clothes. I don't need to get in the middle of that because the state hasn't said, no, I won't let that happen. I'll get involved if I need to. I think that covers everything. Mr. Franklin, anything you want me to amplify on or anything you want to disagree with on the record?
The only things that I have further comment on would be the third item, the Mr. Bill's Wings video.
Yeah.
Upon my review, I want to make sure it's still okay that I may find the need to file a motion in limine as it pertains to relevance, and that would still
Sure.
be okay.
Sure, I'm simply saying it's not being excluded because of a discovery violation. You may have 100 other reasons that it ought to stay out, but it won't be because you got it late. You did get it late. And I'm saying you'll be able to work through the lateness, but doesn't mean it's coming in.
Understood. And just to add this to the record, again, I don't think this is from any ill intent from Ms. Hall, or active ill intent from the DA's office. But the GSR report, the date on it, as I look at it, was December 16th of 2019. So it had been done for.
That's when it was submitted, or that's when it was completed? That would be record time for completing it because the incident.
It said report date, so I'm assuming that's the date that the report was completed.
I'm not doubting you, but that means it sat around for a little while. Excuse me.
I don't have a comment, Yard, because when I spoke to the officer, he told me that he took it a couple months after the incident, and then he was trying to get access to GBI to get the results. As soon as I pulled it up and saw that they were ready, I forwarded that same moment to Mr. Franklin. So I didn't even look at it other than seeing if it was present or not. I didn't examine it.
As I look at it in detail, and I hadn't looked at it in detail before, the laboratory received the evidence on October 29th of 2019.
That would make sense.
No, I just said it's today.
And so they received the clothing and stuff on the 29th of October. They received from Atlanta Police Department a sealed GSR collection kit identified as containing samples from the hands of Cleveland Dunham that was received November 5th of 2019.
So they worked quickly. If it may well be they got their results in December.
Yeah.
Okay.
So to the extent that it sat around for 6 months without being provided to the DA's office, and then we're still at this period of 2 months, 2.5 months after my deficiency request on that. I'll add that to my argument as well.
Okay, noted. Well, I'll get something in writing that memorializes this, and we will go from there. So you'll get jail calls, Ms. Hall, to Mr. Franklin. And
it would seem the only thing remaining would be we still would have a motion to suppress statements as it pertains to the conversation when he got out of the car.
Right, the on-scene interview, if you will, we do need to work through that, and that would be Investigator G,
Yes,
who would be your witness?
yes.
Okay, then why don't we reset this? It would be a Tuesday if you want Mr. Dunham to be here, because that's when we're able to bring inmates over, and we'll just need to get with Ms. Nelson to get that on a Tuesday calendar, so that we can have this be in person. We can have it on a non-Tuesday, but still require the detective to be here. It's just sort of a question for you and Mr. Dunham to work through.
The sooner the better.
Okay.
The one thing that I will also add, the case that Ms. Hall does not have, the aggravated stalking case, Assistant District Attorney Marshall Hodge has that case. An attorney had been hired for Mr. Dunham on that case, but he's not satisfied with that person's services.
Okay.
I was never really aware that somebody else was like really working it, so I've always kind of had it on my radar and I still have my file
Yeah, I
for
always
it.
thought that was your case.
And I filed a bond motion on it a while back. That's I had assumed it was gonna be part of this stuff today, but
Mr. Cowan.
Yeah.
Okay.
So Mr. Dunham desires to have me be the counsel of record on that case. And given the nature of trying to have a global resolution, I have no objection to that. I'm happy to do it.
Okay, your name is listed after Mr. Cowan is listed twice. He has the coveted star as lead attorney. Have you filed an entry in the case?
I believe so. That's how I got my name on the case. I don't know if I need to file a new one to sub as the lead counsel again or something to that effect, but.
No, it looks like in July, you did just that. Nope, that's Miles Cowan's entry of appearance, July 31.
This one should have been either like in December of last year or January of this year because.
Yours is January 2, but it is older than Mr. Cowan, so that's probably why he supplanted you as lead attorney. I don't want to get in the middle of that. I guess that's a conversation for you and Mr. Dunham and Mr. Dunham and Mr. Cowan. He has the more recent entry of appearance. I haven't seen him in connection with this case. I've seen you.
But one thing that's of the utmost importance to Mr. Dunham, we would like to have that bond motion heard as soon as possible. I spoke to Ms. Hodge. I initially thought everything was going to be today, and I realized that the stalking case wasn't listed. I gave Ms. Hodge a call and asked, would she be able to dial in today, but she hadn't had any real notice of it. So she said she needed a chance to try to locate the complaining witness in that case. We've also had conversations about other things pertaining to the case.
Okay.
So we would just like to have that bond reconsidered as soon as possible, because again, that is the only case that, from what I can tell on the booking screen, is holding Mr. Dunham.
That's correct. I mean, I'm the one who denied him bond. I remember the bond hearing, and he has 2 other cases. Other judges may have thought there was wisdom in setting bond in those cases, but we can revisit it. He needs to sort out who his lawyer is on that, because Mr. Cowan he has this entry of appearance. He also has a motion for bond that's been filed. So I just need to make sure we've got the right people in the room for that. But I will get the order in place for the discovery in this case. And we'll go from there. Ms. Hall, anything else? You'll work with Ms. Nelson about setting a date for the suppression hearing. Okay.
Nothing further.
With whatever Investigator G's schedule is.
Do we know how long we'll need for the hearing?
Pardon me?
Do we know how long they will need for the hearing?
30 minutes.
Yeah, I don't think we very.
30 minutes may be too much. We don't need a long time for that.
Yeah, so if you block out an hour, that's more than it could fit on one of our Tuesday calendars, no problem.
Okay, I was just trying to figure out if it was gonna be, how long it was gonna be, so I would know where to block it.
Yeah, not like our last suppression hearing with Mr. Harvey.
Okay.
Had his ankle monitored.
Yes, I heard.
Yeah. Does ICE know about those two guys?
They might now. I'm not sure.
All right. Thank you, Mrs. Nelson. Anything else, Mr. Franklin?
I'm sorry.
No, you guys, if you need to chat for a minute, that's fine.
It was a question about how to make sure that I'm the attorney on the aggravated stalking case. So
Okay.
he's essentially, I'm gonna say firing Mr. Calvin.
Okay, but then Mr. Cowan needs to withdraw, just so that'll be, Mr. Dunham's family can reach out to Mr. Cowan.
Okay, yeah.
That shouldn't be a conversation Mr. Franklin has to have.
I'm in touch with his wife. I think she's actually watching on YouTube now. So
Okay.
I'll reach out to her after court.
Got it. All right, that's what we're gonna do. Thank you, everyone.
You're not taking them away this year, right? Okay, I'm gonna make sure I have a chance to talk to them. That's basically my fault.